The case between the tobacco company and the Uruguayan government was from a series of measures that this country enacted on tobacco control. It can be highlighted that the measures promoted by the Ministry of Health were that only one reference could be marketed per family of cigarettes, and use 80% of the pack display within health warnings, which only leaves 20% to put the name of the brand of the cigarettes. This is why the tobacco company Philip Morris is suing to allege that rights such intellectual property are being violated and that there was no investment protection within the country. However, the state asserts that the decisions are made to protect public health. For the resolution of this conflict was based on Article 42 of the ICSID Convention, and also the government law in this case is the BIT, or Bilateral Investment Treaty, supplemented by such rules of international law as may be applicable.
On the Philip Morris against Uruguay case, there is a central dispute regarding to measure adopted by the state of Uruguay such as posting information about the health risk relative to smoking and tobacco consumption in general, measures that were the object of a lawsuit brought by the companies. In the first approximation, Uruguay has one of the Latin American highest smoking rates, tobacco consumption, and Uruguay has massive health implications for its population and affects the Uruguayan economy considerably. Against this background, Uruguay has engaged important anti-smoking policy measures and adopted with principles and regulations. In this order of ideas, the legal issues are focused on the Abal Hermanos S.A., Philip Morris brand Sàrl, and Philip Morris production. Instead, arbitration against Uruguay for breach of obligations under its bilateral investment trade with Switzerland. But this time it's important to understand that the Philip Morris against Uruguay involved an investment dispute which the found company's subsidiary of parent company Philip Morris International Inc., a company incorporated in the U.S. but registered in Switzerland, so the state of Uruguay argued the expropriation of the brand variants, including goodwill and intellectual property rights.
The International Center of Settlement of Investment Disputes heard a dispute between Philip Morris Brands Sàrl and Philip Morris Products S.A. and Abal, Hermanos S.A. versus República Oriental del Uruguay, in which ICSID dismissed the plaintiff's claims regarding expropriation failure to provide fair and equitable treatment under the Switzerland Uruguay BIT treaty that entered into force on April 22 of 1991, and hindrance in the use of trademarks. The summary of the case is based on the power of Uruguay to regulate public health matters and whether this can be absolute in accordance with obligations acquired through international trade and treaties with other countries. In principle, we can conclude that countries are required to have legal stability in order to enter into bilateral economic investment agreements based on fair, non-discriminatory, and preferential treatment clauses vis-a-vis and other companies with the subscribing country. The thesis accepted by the court is that the measure taken by local government is aimed at protecting public health, so that actions for the protection of citizens cannot be understood as expropriation. In addition, the regulatory exercise of a state must always tend to the general interest, an action that moves the fair and equitable treatment to a second plane in view of the irrelevance of the preferential treatment with respect of the social interest. Now, from such consideration, it is inferred that when preferring public health as a right of general interest over the trade of goods and services as appropriated, it must be analyzed to what extent is allowed to ally the general interest within the dispositive power of the state to deviate from the obligation assumed in the economic investment treaty signs for those where the exploitation of mineral or fossil fuels is agreed upon There is a story of multiple cases when the general interest is not enough to deviate from the contracts and to risk acquired. Incidentally, the same was extended to a right to trademarks, which was accused of being expropriated signs within Article 11 of the TBL. The commitments acquired not include the right to trademarks, a situation that opens a window of legal insecurity in the face of future claims made by other companies in the same terms in the case under examination.